Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. I'm not in my traditional dress today because I'm getting ready to go to the firing range and celebrate. So here's the question. Do 18-year-olds have constitutional rights? Well, I'll answer that in just a minute. The Fourth Circuit recently issued an opinion in a gun case that I think is going to have some far-reaching effects. So here's the situation. The litigants in that case brought an action against the Alcohol, Tobacco, and Firearms Department or Division, and they sought to overturn the ban on 18-year-olds purchasing handguns. Since about the 1960s, the law has been that an 18-year-old can buy a rifle or a shotgun and can have a pistol gifted to them by their parents or another adult, but they can't go into a gun store and buy a handgun. That has always been the law since the 1960s. It arose at around the time that President Kennedy was assassinated and in the years that followed that. So that was the law. And the law has really never been effectively challenged since that time. Until recently, when an 18-year-old young woman said, look, I go out and I'm out in the fields, I'm an equestrian instructor, I'm out in rural areas, and I'm not always dealing with people that I know. And I believe that having a firearm, a handgun, for my protection is much more effective than having something like a rifle or a shotgun. Particularly for an 18-year-old woman to use in her own defense, a handgun is clearly the preferable tool. And so that was the argument. And the argument that the government made was, well, we have the right to regulate firearms, and we believe that the regulation that forbids an 18-year-old from having a handgun is a reasonable regulation. So it went to the Fourth Circuit, and the Fourth Circuit only recently issued an opinion, and I'm going to read just a little bit of the intro of that opinion. When do constitutional rights vest? At 18 or 21? 16 or 25? Why not 13 or 33? In the law, a line must sometimes be drawn, but there must be a reason why constitutional rights cannot be enjoyed until a certain age. Our nation's most cherished constitutional rights vest no later than 18, and the Second Amendment's right to keep and bear arms is no different. And then here's what the court said about what the plaintiffs wanted in that case. Plaintiffs seek an injunction and a declaratory judgment that several federal laws and regulations that prevent federally licensed gun dealers from selling handguns to any 18, 19, or 20-year-old violate the Second Amendment. We first find that 18-year-olds possess Second Amendment rights. They enjoy almost every other constitutional right, and they were required at the time of the founding to serve in the militia and furnish their own weapons. We then ask, as our precedent requires, whether the government has met its burden to justify its infringement of those rights under the appropriate level of scrutiny. To justify this restriction, Congress used disproportionate crime rates to craft over-inclusive laws that restrict the rights of overwhelmingly law-abiding citizens. And in doing so, Congress focused on purchases from licensed gun dealers without establishing those dealers as the source of the guns 18 to 20-year-olds used to commit crimes. So we hold that the challenged federal laws and regulations are unconstitutional under the Second Amendment. Despite the weighty interest in reducing crime and violence, we refuse to relegate either the Second Amendment or 18 to 20-year-olds to a second-class status. And that was the ruling of the court in that case. It's a good ruling for a number of reasons. First of all, 18-year-olds have the right to vote. They are often drafted into military service. It makes no sense to entrust an 18-year-old who has been drafted into the military and assigned to become a military policeman. It makes no sense to allow him to carry a handgun in the performance of his duties, while at the same time restricting a similar 20-year-old or 18-year-old in the civilian life from having that same right or opportunity. In fact, this is what the opinion says about that. The irony does not escape us that the government's reasoning, the same 18 to 20-year-old men and women we depend on to protect us in the armed forces and who have since the founding been trusted with the most sophisticated weaponry, should nonetheless be prevented from purchasing a handgun from a federally licensed dealer for their own protection at home. We refuse to accept this conclusion. These men and women, who historically have served either voluntarily or by conscription, may not be read out of the people in the Second Amendment. And that is essentially what the court did. Now, this is a wonderful opinion. It's available from the Fourth Circuit's website. You can go to their daily opinions, and it's the it's the case that involves the ATF. It was the only one on the website this morning when I looked, and you'll find it very easy. It's an 83-page opinion. The principal opinion is 83 pages. And it's worth reading because it goes through the history both of the militia as well as the Second Amendment. And it is a tour de force in the area of constitutional law. It is written by Judge Richardson, and he did a marvelous job of explaining why there is no rational basis for restricting the gun rights of 18 to 20-year-old Americans. And that is something to celebrate. So one of the things that the court did was it looked at the rights at the time of the ratification of the Constitution. And then it looked at the evidence that Congress supplied for its choice to regulate guns from 18 to 20 years old. It went through this in painstaking detail. It provided appendices to the opinion that listed the state militia laws that were in effect at the time of the founding. And it concludes with these two marvelous paragraphs. But while Congress or judges may have struck a different balance long after ratification, that role is foreclosed to us by the balance that the founders chose. We cannot now second guess or undermine their choice. History makes clear that 18 to 20-year-olds were understood to fall under the Second Amendment's protections. Those over 18 were universally required to be part of the military, and part of the militia rather, near the ratification, proving that they were considered to be part of the people who enjoyed Second Amendment rights. And most other constitutional rights apply to this age group. And Congress may not restrict the rights of an entire group of law-abiding adults because a minuscule portion of that group commits a disproportionate amount of gun violence. Congress's failure to connect handgun purchases from licensed dealers to youth gun violence only serves to highlight the law's unduly tenuous fit with the government's substantial interests. 18 to 20-year-olds have Second Amendment rights, and the challenge laws impermissibly burden those rights. As a result, we vacate the district court's grant of a motion to dismiss, reverse the denial of summary judgment, and remand for further proceedings. So what that means is it granted the summary judgment motion of the plaintiffs in that case for an injunction. Now, whether that injunction will be applied nationwide or just within the Fourth Circuit is yet to be determined, because that has to be determined by the district court in that case. But it is indeed a great reason to celebrate. But while we are talking about celebrating that, it is worth noting that not everyone subscribes to this view. The decision is a 2-to-1 decision. And in a dissent, Judge Wynn manifests his failure to understand just how important these rights are. Here is one of the things he says. I do not share it. Indeed, in a country that boasts a Congress, bench, bar, academy, and electorate that are all attentive to the prerogatives of gun owners, where many may conceal their weapons, carry them openly, or stand their ground, and where civilian gun ownership rates are second to none, The majority's second-class status concern is simply surreal. No, the Second Amendment is not exceptional because it uniquely is oppressed or imperiled, but rather because it is singularly capable of causing harm. That ought to give you pause. The judge is saying that the Second Amendment causes harm. The right to keep and bear arms causes harm. Without examining any of the evidence, without putting forth any statistical basis for this ridiculous assertion, the court simply, as a fait accompli, says it causes harm. And yet there are estimates of over 500,000 defensive gun uses every year. Hundreds of thousands of those where a shot is not even fired. And the judge concludes that restricting the rights of 18 to 20-year-olds somehow improves public safety and that the Second Amendment imperils it. This is why it is important to elect people to Congress and the Senate who understand that you have a Second Amendment right and that there is a duty to preserve that right. And that when a judge takes an oath of office and agrees to support and defend the Constitution of the United States, it means not just the parts of the Constitution you like. It means you have a duty to support and defend the Constitution in whole, including the Second Amendment. Do I like the idea that Nazis can march through a Jewish part of town and claim that they should be exterminated? Absolutely not. That is repugnant to every clear-thinking individual. And only people who are so steeped in hatred can express a belonging to that kind of ideology. But the reason that we allow that kind of purulent speech to be tolerated is because the answer to bad speech is more speech. It is not to regulate the speech of others. Similarly, the answer to gun violence is not to overregulate a group of people who do not partake in it and who do not are not a significant component of it, but rather it is to arm the populace and allow them to own and carry and display where necessary their right to keep and bear arms. Those God-given rights are terribly important. Judge Richardson and the Fourth Circuit got it right. Judge Wynn got it wrong. And we need to ensure that a lot more judges like Judge Richardson are put on the bench as opposed to judges like Judge Wynn who do not understand the importance of constitutional rights. And let me explain one further thing. The reason that people are marching right now in Cuba waving American flags is because that flag is a symbol of liberty. And the only reason that Cuba is able to put down that kind of public outcry for freedom is because those people are disarmed. Well, that's all I have for you today. I hope you've found this interesting, helpful, enjoyed it. If you would, I'd really appreciate it if you haven't already to tap on the subscribe icon and tap on the notification bell so you can get all the notifications here on this channel. And of course, I'd love it if you would smash that like button and let people know that this content is worthwhile, and I would certainly hope that you would share it with others. Thank you so much for watching. Have a great day, and I'll catch you next time.